arresting transmission from patients who do not show symptoms is actually
Thank you, President. Caribbean Court of Justice, original jurisdiction. Judgment delivery in BBOJ number 1 of 2019 between Rock Hard Cement Limited and the State of Barbados and the Caribbean Community and Arawak Cement Limited. The full bench sits today comprising their honors, Mr. Justice Saunders, President and the presiding judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnat Lee.
Good morning, Counsel.
Mr. Justice Barrow.
Good morning, Counsel.
Mr. Justice Burgess.
Good morning, Counsel.
And Mr. Justice Jamada.
Good morning, Counsel.
Please state your appearances for the court. Thank you.
Good morning, Your Honors. Alan Wood and Simone Mayhew appear for the claimant Rock Hard Cement Limited.
Good morning, Your Honors. If it pleases this honorable court, I am Gail Scott, and I appear in association with Mr. Jared Richards for the first defendant.
May it please Your Honors, Juanita Bab Schiffer and O'Neill Francis appearing on behalf of the community.
Good morning, Your Honors. Eamon Courtney appearing for Arawak Cement. I apologize for the absence of my junior, who is presently before the Court of Appeal in Trinidad and Tobago.
Thank you. Good morning again, Counsel. I propose to read a summary of the court's judgment. The summary is not intended to be a substitute for the reasons of the court, nor is it to be used in any later consideration of the court's reasons. The court granted the claimant, Rock Hard Cement Limited, special leave on 7th November 2019 to commence proceedings against the defendants for judicial review of a decision of the Caribbean Communities Council for Trade and Economic Development, COTED. COTED is the organ of the community, the second defendant, that is responsible for determining the common external tariff of all goods which do not qualify for community treatment. On 17th of June 2019, COTED granted the application by the State of Barbados, the first defendant, to suspend the CET of 5% on other hydraulic cement and to replace it with a tariff of 35%. The application sought was for 5 years, but it was granted for 2 years. Rock Hard alleged that this decision was in breach of a legitimate expectation that Barbados would maintain the CET rate of 5% on other hydraulic cement, or that at least the CET rate would not be changed without prior consultation with Rock Hard. The court also granted Arawak Cement Company Limited, the only domestic producer of cement in Barbados, leave to intervene in the proceedings. On 12 June 2019, Barbados applied to COTED for the CET on other hydraulic cement to be suspended for 5 years and for it to be replaced with a tariff of 35% for that period. The request was on the basis that there was a critical shortfall in government revenue being experienced in Barbados, a need to support an industry in that country, and that the product was of strategic importance to the economic development of Barbados. The request was made pursuant to subparagraphs D, F, and G of Article 83.3 of the revised Treaty of Chaguaramas, the RTC, as amended by the protocol to amend Article 83. At the 80th special meeting of COTED, held on 17 June 2019, COTED authorized the suspension of the CET and application of a tariff of 35% on other hydraulic cement for a period of 2 years. There was no consultation with or even notice given to ROCAD prior to the making of the request, even though at the time of the granting of the request, both defendants were involved with ROCAD in proceedings before the court concerning the correct classification of cement imported by ROCAD. Those latter proceedings resulted in a judgment delivered on 6th August 2019, the classification ruling, in which the court ruled that ROCAD cement was to be classified as other hydraulic cement, for which the applicable CET range is 0 to 5%. ROCAD was only notified of the suspension at a meeting with representatives of Barbados on 2nd September 2019, where Barbados also indicated that the statutory instrument to implement the 35% tariff was being prepared. By letter dated 24th September 2019, Barbados confirmed that the new tariff was implemented on 9th September 2019, when the Customs Tariff Amendment Order 2019 was published in the supplement to the Official Gazette number 73. In its originating application, ROCAD sought judicial review to quash the grant of the suspension of the CET to Barbados by COTED. It also sought an order restraining Barbados from applying the tariff of 35% to the importation of other hydraulic cement, and a further order directing Barbados to apply instead the CET of 5%. ROCAD argued that the suspension was unlawful, irrational, in breach of ROCAD's legitimate expectation, and that it was ultra-virus. The court considered the grounds argued by ROCAD under the following three headings: substantive legitimate expectation, consultation, which subsumed the claim to a procedural legitimate expectation, and judicial review for ultra-virus on other grounds. In 2015, the tariff on other hydraulic cement stood at 60% as a result of a derogation sought and obtained from COTED by Barbados in 2001. At the instance of ROCAD, Barbados unilaterally restored the tariff to the CET rate of 5%, expressly to support ROCAD's business, as confirmed by a cabinet note confirming the reduction. ROCAD based its claim of a substantive legitimate expectation on its communications with Barbados that resulted in that reduction. ROCAD claimed that it relied on those communications to invest $5 million to establish its business, with the expectation that Barbados will not alter or seek an alteration of the CET of 5% on other hydraulic cement. ROCAD also asserted that during the previous proceedings before this court involving the parties, COTED would have been made well aware of the position of ROCAD as being the sole importer of other hydraulic cement into Barbados, with a legitimate expectation that Barbados would always apply the CET of 5% on such imports. Barbados denied that the communications in question gave rise to a legitimate expectation that it would permanently apply the CET of 5% on other hydraulic cement, or that a suspension of that rate would never be sought, as this would mean that successive governments of Barbados would also be bound not to ever invoke the right afforded by Article 83 of the RTC to seek suspension or alteration of the CET. Barbados also argued that ROCAD was aware of its intent to suspend the CET and increase the tariff since July 2018, and that even if ROCAD had any legitimate expectations claimed, Barbados would have been entitled to disappoint it where overriding public interest considerations existed. The community and the intervener both agreed with Barbados, with the intervener adding that Barbados was not competent to make any unqualified representation that would bind the community, and that COTED, the actual decision maker, did not make any such representation. The court examined the doctrine of legitimate expectation generally and found that, as was stated by the International Court of Justice in the case of Bolivia against Chile, The doctrine has no place in general international law. The court concluded, however, that principle and authority alike support the applicability of the doctrine in regional economic integration arrangements, such as the Caribbean Community and the European Union. As individuals also derive rights under community treaty arrangements, in a case of this kind, where the community is the ultimate decision maker, the action of the community and of states acting on behalf of the community may create legitimate expectations in a person which community law will protect. In Trinidad Cement Limited against the community, this court affirmed the applicability of legitimate expectations in Caribbean community law in a context not very different from that in this case. And the court emphasized then that adherence to the rule of law required that the community not disappoint legitimate expectations it had created, unless an overriding public interest consideration so required, or the possibility of the adoption of a change in policy was reasonably foreseeable. The court also noted that the prerequisites for invoking legitimate expectations were more fully spelled out in the EU cases, and the court referenced in this regard the case of Branco and the Commission. The court also cited the subsequent case of Infinis Energy Holdings Limited against Her Majesty's Treasury and Her Majesty's Revenue and Customs in support of the view that there were 4 prerequisites for successfully invoking the doctrine of legitimate expectation against the community. And these were: 1, the assurance or promise given to the person concerned must originate from or properly be made on behalf of the community. 2, the assurance must give rise to an expectation on the part of the person to whom it is addressed that they will receive or continue to receive some benefit. 3, there must be the possibility of the adoption of a change in policy that should not have been reasonably foreseeable, or rather the possibility of the adoption of a change in policy must not have been reasonably foreseeable. And 4, there must be no overriding public interest consideration that justifies the disappointment of the expectation. The court said that these conditions were cumulative and that the burden was on ROCAD to establish the first 3, at which point the burden shifted to the community to justify disappointment of the expectation by reference to the overriding public interest consideration. The court found that in this case, it was only necessary to examine the first condition, noting that the requirement that the undertaking must have been given by or on behalf of the community is based on substantial reasons related to the very nature and scope of community law. In referencing its 2015 communications with Barbados, ROCAD did not claim to be the beneficiary of a representation emanating from COTED, the community organ that is the decision maker in this case. There is also no evidence, nor was it submitted, that Barbados was authorized by COTED to make the alleged representations for or on behalf of the community. Further, the allegation that COTED subsequently became aware of the alleged representations is insufficient to render COTED a party to the making of those representations, as were allegedly made by Barbados. The court made no comment on whether those representations could give rise to a claim for substantive legitimate expectation against Barbados in domestic law, but the court found that ROCAD's claim to a legitimate expectation before this court must fail. The court stated, however, that since COTED would have had knowledge of ROCAD's extensive stake in the application made by Barbados in July 2019, COTED ought reasonably then to have been concerned to discover whether Barbados had notified or consulted ROCAD prior to making the application and received all pertinent information about how the request could impact ROCAD. The court again drew attention to Article 26 of the RTC, the stated purpose of which is to enhance the decision-making process in the community. The court had earlier stressed in TCL against the community that a duty exists to ensure that all the processes involved in making and determining requests for the reduction or suspension of rates under the CET should be transparent, efficient, and effective, unquote. This duty, which in matters like these rests primarily on COTED, includes a duty to try to correct any weaknesses that emerge in the system and to ensure, as far as possible, scrupulous adherence to that system. Following the court's decision in TCL and the community, the member states actually entered into a protocol to amend Article 83 of the RTC. And that protocol is currently being provisionally applied, pending notification by all the member states, pending ratification by all the member states. COTED also generated what is referred to as the revised procedures and forms for processing requests for suspension of the CET relating to the protocol, the revised procedures. These revised procedures were approved at the 40th meeting of COTED on the 23rd to 24th April 2015. They're divided into three parts. Parts A and B are for applications made under subparagraphs A, B, and C of Article 83.3, while Part C is for applications made under paragraphs D, E, F, G, and H of Article 83.3. While Parts A and B are in force, the revised procedures stated that Part C will only become operative when the protocol formally enters into force upon ratification by the member states. As Barbados made its request pursuant to subparagraphs D, F, and G, it is Part C that is pertinent to this case. Part C prescribes 3 steps for the processing of requests for suspension. Step 1 requires that the member state includes in its application alternatives considered to address the concerns faced by the member state, as well as a statement on the potential impact on an entity, industry, and/or importers of the request. Step 2 requires the Secretary General to circulate the application for consideration prior to the meeting. Step 3 requires the member states to notify the relevant local entities of the request and to provide COTED with any information relevant to the request. There is nothing to suggest that in the making of either the request by Barbados or the COTED decision, the need for consultation with ROCAD was considered either by Barbados or by COTED in circumstances where both bodies were fully aware of the impact the decision would have had on ROCAD. The defendants did not dispute that the steps of Part C were not followed, but they submitted instead that they did not need to follow those steps because Part C had not yet been made operative. Noted that it has been 11 years since its judgment in TCL against the community, and 5 years since the approval of the revised procedures. The court found that the failure to bring Part C or some appropriate alternative into force cannot mean that there is simply a huge void in relation to a defined procedure, inclusive of consultations, for applications made pursuant to subparagraphs D, E, F, G, and H of Article 83.3. Such a void would be contrary to good governance, the rule of law, and fundamental values and principles embedded in the RTC, and must be seen as a weakness in the system which the community has a duty to correct. As long as that weakness in the system subsists to the prejudice of rights inuring to the benefit of a private entity, the community will be failing to carry out properly the duty imposed on it by Article 26 of the revised treaty. The importance and value of the consultation process will vary from one case to another. Considering the facts surrounding the request and the process followed in the making of the COTED decision, the court found that the defendants failed in their legal duty to ensure that ROCAD was consulted before the application for the suspension was made and approved. The court also found that the community had failed in its duty to establish and maintain an efficient system of consultations at the national and regional level. The court did not now consider that these failures should lead to the drastic measure of the annulment of the COTED decision in light of A, the fact that in this case, the consultation would have been limited to obtaining information as to the impact of the suspension, and B, the context of the particular grounds on which the request was made afforded the policymakers a wide discretion. The court did consider, however, that the failures should attract appropriate declarations, be in a form of other relief claimed in the originating application. In respect of ROCAD's claim that the COTED decision should, on other grounds, be reviewed and declared ultra vires, the court reiterated that the court's remit in judicial review is a broad one, with the overarching concern of maintaining and fostering the rule of law. Though ROCAD based its claim on several grounds, the court did not consider it necessary to examine each of those submissions in minutiae. The court examined the information that was placed before COTED and found that that information pointed to a need to support an industry, and it gave an indication as to the strategic importance of that industry to Barbados. Thus, though not much was said to COTED specifically in support of the critical shortfall in government revenue, the court could not reasonably come to the conclusion requested by ROCAD, either that COTED's decision was so wholly disproportionate as to be unconnected with the facts, or that the decision was otherwise ultra vires. The court stated that the inescapable fact is that ROCAD cement is in competition with cement locally produced by the intervener. It is ultimately a matter of domestic economic policy, whether consistent with its development strategy, the state of Barbados wishes to promote the importation of ROCAD cement or to encourage the intervener's local cement production. And if one or the other, what measures it should take. Successive administrations must be permitted the policy space to take such measures as they may consider appropriate. But any such measures taken, whether by Barbados or ultimately by COTED, must comply with the rule of law. The court therefore concluded and declared, A, the community failed to establish and maintain an efficient system of consultations at the national and regional level. B, the defendants failed to ensure that the claimant was consulted before the application for the suspension of the CET was made and approved. C, the other claims are dismissed. The court declined to make any order as to costs, but has opted instead to hear the parties on the issue of costs. The court would therefore order that each party is to make written submissions to the court within the next 2 weeks. We don't expect those submissions to exceed, in each case, maybe 4 to 5 pages. And after having looked at those submissions, the court would then make its cost award in this matter. Is there anything that Council would like to state? In that case, Madam Registrar, can you please bring the proceedings to an end?
Thank you, President. The court stands adjourned. Thank you.